has said that if you do something for a political purpose, and that's defined as an effort to influence an election, to advocate the election or defeat of a candidate, you spend $25 doing that, you have to register and abide by the laws of our state. The Government Accountability Board was duty-bound to follow that law. Now, what state law also said for a very long time, in fact, it dates back to an act of the 1905 legislature, is that corporations could not engage in election spending. That later was expanded to the use of treasury funds by unions, for example. The Government Accountability Board didn't create that law, and it wasn't the Government Accountability Board that eliminated enforcement of that law. It was the United States Supreme Court. In the Citizens United decision, what the United States Supreme Court said is that corporations can engage in unlimited election spending. And what that effectively did is it nullified, it overturned half of that 1905 law. In 1905, the Wisconsin legislature banned corporate campaign contributions. They remain banned. Corporation can't directly contribute to your campaign. But that law also prohibited election spending by corporations. And when you use the term corporation, I know that what that means to many people is a business corporation, but a corporation, in fact, can be a nonprofit corporation, it can be a for-profit corporation, it's an incorporated entity that we're talking about. They were prohibited since 1905 from spending money for a political purpose, to influence elections in Wisconsin. The United States Supreme Court overturned that. What the Government Accountability Board then had to do is accommodate that ruling. Write rules based on Wisconsin law that allows for corporations to engage in direct advocacy for the election or defeat of a candidate. That's exactly what GAB 1.91 did. And it is not a matter of speculation or conjecture about who is captured by this rule or who ends up having to report under this rule. Because this rule was in effect for the 2010 election cycle. You can go on our website, we have a listing of all the 191 corporations, all the groups that registered under GAB 1.91 and disclosed their spending. Now it should be noted here, and here's again an area where there's been an awful lot of misleading discussion so far. You all, when you engage in your campaigns, you have to disclose your spending, you have to disclose your donors. 191 corporations only have to disclose their spending. There's not a single donor disclosed. There's nothing, so what you've got here, this rule, provides for exceedingly minimal disclosure. It gives the people of Wisconsin no ability to know where the money came from or who really is behind all this advertising that's being done. It simply says this much money was spent by this organization on behalf of this candidate or in opposition to this other candidate. And that's what 191 was doing in 2010. It's exceedingly minimal disclosure. It's less disclosure than you're required to provide the people of Wisconsin. And you can go on our website and you can see a list of the groups. And there aren't $25 spenders on there. We're not talking about individuals who are passing out flyers or putting billboards up on barns. We're talking about big interest groups, non-profit corporations and for-profit corporations alike. And to be honest with you, it's almost exclusively non-profit corporations. You mentioned the 501c4s, and you're correct in saying that a 501c3 organization is prohibited under federal law from endorsing candidates or engaging in any election campaign. But 501c4s and 501c6s can engage in that kind of activity, and they do, and they don't have to disclose their donors to the public. You can't go on the IRS website and find a 501c4 as donors. So what we're talking about here is not disclosure that enables the people to really follow the money. It only allows people to get a sense of the magnitude of the spending by a particular organization. And it's almost exclusively nonprofit 501c4 or 501c6 corporations that are engaged in this spending under 191. So, you know, what you've got before you is not a technical bill. It is not simply a bill that seeks to block the continued enforcement of this particular rule. This is a bill that aims to eliminate what little disclosure we have of these organizations that were reporting their spending under GAB 1.91 in the 2010 election cycle. And it is also legislation that seeks to go way beyond that and preempt any future rulemaking with respect to corporate election spending. The earlier testimony was simply wrong, and it was extraordinarily misleading for your committee to be given that characterization of both the rule as it exists, as it has existed, and what this legislation would do. Wisconsin needs more disclosure, not less. The simple fact of the matter is that passage of this bill will create less disclosure. The groups that are listed on our website that reported their spending, not their donors, but their spending in the 2010 election cycle, that would disappear for the people of Wisconsin in the future. That's a simple fact of the matter. I think what this legislation also would do, if passed, is make candidates matter just a little bit less. You already are in a situation where candidates matter less than what the interest groups are doing. They're outspending candidates in an awful lot of races because they're playing by an entirely privileged set of rules. You have to disclose your donors. You have to disclose your spending. You have to do all these things that they don't have to do. They can raise money from sources that you cannot tap into. They can take money in unlimited amounts from sources that are prohibited for you to accept. They already are in a situation where if they want to blow you out of the water, push you to the sidelines, and turn you into a bystander in your own election, they can do that. And what this legislation would do is further enable them and make them just a little bit more powerful and make candidates a little bit less relevant. That would be a practical result of the passage of this legislation. And then the practical result of this legislation is that going forward, the Government Accountability Board would be prohibited from addressing corporate election spending at all. And you know, it's not just that they would have to steer clear of the $25 threshold. That wasn't of their creation anyway. That's in state law. They would not be able to engage in any rulemaking regarding corporate election spending. Now, the fact that we have corporate election spending today in Wisconsin is not the Government Accountability Board's doing. It was the United States Supreme Court that did that. And what the board had to do was accommodate that spending that was prohibited for over a century in Wisconsin. You're going to have rules, folks, that accommodate that corporate election spending. Now, in the past, what they would do is they would play the phony issue ad game, and they wouldn't come out and say vote for a particular candidate or vote against a candidate. What the United States Supreme Court did 2 years ago is said, no, they can come right out and say, vote for Representative Tauken, vote against Representative Leininger. They can come right out and say that now. There have to be rules that accommodate that because the United States Supreme Court said so. And so I don't know where you'll leave us if you reject that rule and prohibit any future rulemaking regarding corporate election spending. Then we're in a sort of a lawless environment. We won't know what the heck how do you deal with this whole new category of spending that was opened up 2 years ago? Bottom line is that Wisconsin needs more disclosure, not less. This creates less disclosure, significantly less disclosure. Millions of dollars worth of spending will disappear from public view if this legislation is enacted. And what you really should be doing as a committee is setting this silly foolish legislation aside, turning your attention to creating real logical disclosure for the people of Wisconsin. And you're making a huge mistake based on misinformation if you go forward with this legislation.
Questions? Representative Stone, you mentioned 191 groups. How many of those are there?
There was over a dozen. I don't have the list is on our website. There were over a dozen organizations. I think there might have been a for-profit company in there, but they were it was 501c4s and 501c6s. It was nonprofit corporations, political organizations that raise money from God knows where because they don't have to disclose their donors, and they should have to disclose their donors. The people of Wisconsin deserve to know who's really paying for those ads. There should be disclosure of that, but the GAB did not have the legal authority under existing state law to write the rule that would give the people of Wisconsin what they deserve. That would require an act of the legislature. So to suggest that the GAB went beyond its statutory authority, that is a ridiculous statement. The GAB, I think, those 6 judges would have liked to give the people of Wisconsin what they deserve, which is disclosure of where that money's coming from, but the GAB did not have that statutory authority. So they went right up to the line of where they could go, and they didn't go an inch farther. And what they left us with was highly minimal disclosure. We got a dozen or so organizations listed that collectively spent millions to influence the 2010 elections. All we know is the amount that they spent and who they spent it for or who they spent against. We don't know where that money came from, and the people of Wisconsin should know where every penny of that money comes from. You have to disclose your donors. Those participants should disclose theirs. Unfortunately, that can't be done by rulemaking. That can only be done by an act of the legislature, which is exactly what your committee should turn its attention to. That's what you should be really focusing on, is the disclosure that the people of Wisconsin want, not taking away what little disclosure the people of Wisconsin currently have.
Any other questions? Thank you for your testimony. Appreciate it.